Hello and welcome to Rapid Fire Wednesday, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, partner in WR Immigration San Diego location, and I am joined today with co-managing partner of WR's Boston office, Miki Matrician. Welcome to you, Miki. Good to see you again.
Hi, Kim.
All right, so we're going to get started. Again, we really listen to what our corporate partners are talking about, what their pain points are. And many corporate immigration professionals have noted in response to one of our benchmarking surveys that one of their and their foreign national employees' concerns is the ever-expanding processing times for permanent resident process based on the labor certification application, aka PERM. So this is a very legitimate concern and one that we thought we would take some time to share some insight on today. This is also the first in a three-part series about the PERM labor certification application process. So today is talking about processing times. Next week, we're going to talk about recruitment methods, specifically DOL versus DOJ. And then the third part of our series, we're going to talk about risks and job changes. So let's move forward with our topic, the fun part about processing times. So, Miki, before we delve into the question about processing times specifically, can you please share with HR professionals a little bit about the permanent resident process and what the PERM application is all about?
Sure. So PERM is the first step of the three-part green card process, and it's based on a test of the labor market. So the employer has to post real ads at specified places by regulation, and only if there's no minimally qualified U.S. worker for the job can the employer file the PERM application, which is basically an online filing based on attestations that the employer did what they said they would do.
So with this PERM process, right, once the minimum requirements have been defined by the company for the sponsored position, and the foreign national employee has confirmed that they actually meet those requirements and can attest to the qualifications, then most HR professionals understand that the next step would be submitting a prevailing wage request to the U.S. Department of Labor. So why is this wage request required?
Yeah, it all goes back to the Department of Labor's mission, which is to protect U.S. workers. And so it requires that the employer pay at least the prevailing wage. And that's the way that the U.S. government tries to safeguard against U.S. workers' pay being undercut by foreign national workers' wages.
Okay. Yeah, it is. It's been around for a long time. So because it's been around for a long time, right, the Department of Labor, which you would think would be much faster in processing the wage determinations, has actually been taking a lot longer. So can you explain, Miki, how that impacts the PERM process?
Yeah, essentially, the employer has to have a valid prevailing wage determination before it can file the PERM application. And so these prevailing wage determinations that are issued are specific to the employer and the title and the metropolitan area where the job is based. And the Department of Labor is basically taking between 5 to 15 months, depending on whether the request is for a government database wage or a private wage survey. The prevailing wage processing has a big impact on the timing of the case, essentially because the ads are valid for only 6 months. And companies can either wait to post the ads until the prevailing wage determination is issued, but that kind of prolongs the filing timeline. The other option is to run the ads while the prevailing wage is pending, so it kind of goes in parallel, but then you can't file the application unless you get the prevailing wage determination before you file. So that's where, it's particularly challenging because we don't know how long the Department of Labor will exactly take to issue the prevailing wage determinations. And if the ad essentially expires and we're beyond the 6 months, then the company might have to extend the ads or in some cases run a new ad campaign. It's tough because the PERM's already a cost-heavy process and it takes a long time to get to the point of filing. So the Department of Labor prolonging its processing is a huge headache for companies.
And it looks like there's a lot of strategy that you have to talk with HR professionals about in order to figure out the best process for timing. So, along those lines, right, if the sponsored employee is on an H-1B visa, they have a limited period of 6 years that they can remain in the United States in that H-1B status. So, do the prevailing wage processing times have a negative impact on a person's ability to remain in the US and H-1B status?
Absolutely, unfortunately. So it's not uncommon for people whose perm cases are started kind of closer to the end of the 6 year maximum to run out of time. Where it previously took like 8 to 9 months to file a perm application from start to finish. But, if the prevailing wage is based on not on government data, but on private wage surveys, it can take now up to 18 months or more just to file the perm application. And, there's the wage issue, being so high is also a challenge. Essentially across the country. I mean, if the employer is trying to use government data, for example, for a software developer in the Boston area, there's a prevailing wage of around $90,000 for an entry level job and $157,000 for a more senior level job. Whereas in the San Francisco area, closer to your neck of the woods, Kimberly, the job is around 113,000 for entry level and 215,000 for senior level jobs. So that's really high for most companies. It might be impossible for a company, especially if they're smaller, to promise an employee that wage. And so then they have to turn to private wage surveys, right? If there is a lower wage option through the survey. And that's where, people might run out of time if the prevailing wages are taking 15 plus months.
Yeah, that is a huge concern. And one of the things that I was just thinking about, Miki, is with remote employees, right? If the position allows someone to work anywhere in the country, you might have to look at where is the company headquartered. So the person might be working in your neck of the woods in Boston, but the company is headquartered in San Diego or San Francisco and the wage is much higher. So that's another key component to think about as well. So with H-1Bs, right, we mentioned that they have a 6 year maximum period of stay. And they being the H-1B workers are pretty much the only classification that allows for an extension of their work authorization beyond this regulatory 6 year maximum period of stay. So the way that they can do that is that if the permanent resident process is filed with the government agency at least 365 days before their 6 year maximum, or there's an approved immigrant worker petition and the individual's quota backlogged, that person might be eligible for the company to extend their status in 1 or 3 year increments beyond that 6 year maximum. So that's a little bit of a sigh of relief for some H-1B workers, but not always. So with this potential to extend the H-1B workers' period of stay, what do you recommend when you're talking with HR professionals and global mobility partners that they consider with their immigration policies for sponsorship for individuals for permanent resident status?
Yeah, the easiest answer is to start the green card process as early as possible during a foreign national employee's tenure. Something that I'm recommending to HR professionals these days is try to start the process when the employee has at least 3 years left of H-1B status, if possible, 4 years. So that might mean, companies have to look at their sponsorship policies to see if they need to make an update given these perm processing times.
Okay, it's good advice. So aside from starting the case early, are there any other strategies for HR professionals in order to avoid this type of situation where H-1B workers or even other classifications run out of time?
Yes. So if the company is one that recruits foreign nationals regularly, it's a good idea to see if the HR professional can use the prevailing wage determination for multiple workers. So, these, as I said before, these determinations are specific to the employer and the position and location. So if you are an employer with an office in Boston and an office in San Diego, you can't use the same prevailing wage for employees in those two offices. But if you start a perm for a software developer in Boston in August, then you intend to sponsor someone in December, you might be able to leverage the same determination for the second case, and they can end up saving a little bit of time, a few months, right? In order to use the same prevailing wage, though, it's important to know that the job duties and the minimum requirements have to be the same. And then if that is the case, if they are the same, then not only can you reuse the same prevailing wage, but you can also do one ad campaign for multiple slots for the same role.
Okay. It's a really good thing to think about. So along that similar line, sometimes from the company's perspectives, the roles might not seem like the same because they are in different departments or working on different product lines. Can you still batch those cases?
Absolutely. Yeah. So it's not necessary that the job duties contain every single aspect of the job. And the duties in the case, have to be specific enough to apprise US workers about the role, but it can be broad enough or diluted, so to speak, to cover multiple roles.
Okay. So we will focus on the processing times, the very lengthy processing times for prevailing wage determinations. But we also are in a situation right now where it is taking longer and longer for the PERM application to be adjudicated by the Department of Labor. So with this, how long is it taking the Department of Labor to actually adjudicate the PERM applications once they're submitted for processing?
Yeah, it's a huge pain point for HR mobility professionals. And they need to know that the PERM application processing time is currently at 13 to 14 months to be adjudicated. And then if the application is audited, it'll add an additional 5 to 6 months to the processing time.
Okay. And if you factor that on to potentially 18 months with prevailing wage determinations plus recruitment, we're looking at a really lengthy time. Not to be a Debbie Downer or anything, but it is really something to consider, right, when planning your strategy. So as we've seen, we think that why isn't this getting faster, right? We're kind of out of COVID. We shouldn't have these significant backlogs. But, Miki, do you know why processing times have been increasing over the past few years?
Yeah, it's essentially two things. It's that the H-2B seasonal or temporary work visa category has increased. And that has basically resulted in lengthening times for prevailing wage requests and 989s because the Department of Labor is mandated to prioritize the H-2B visa processes. And it's also an issue of resources. The DOL hasn't received any more funding to address this increase in H-2B visa processing. And so they're working with the same number of analysts. And so the processing time queue has essentially gotten longer and longer.
Well, I guess one of the good news things is we just received a perm that was certified today, and it was filed May 2nd of last year. So that's just a tad bit over 12 months. So maybe there's some hope on the horizon, but it's still a long process.
Our standards have lowered. We're like, oh, yay, 12 months, not 14.
We're like, whoa. All right. So is there anything that global mobility professionals can do to speed up this process other than like wishing that it was faster?
Yeah, that's one of the tough things. And, everybody is always asking us, can we premium process the PERM applications? And the answer is unfortunately no. There's no way to expedite the prevailing wage request. There's no way to expedite PERM processing, unlike with the I-140 immigrant visa petition, which is eligible for premium processing. So really, unfortunately, our recommendation is, to start early as possible, combine cases if you can, and then review if there's an alternative to the PERM process, for example, the national interest waiver or extraordinary ability or multinational manager, so that you can try to bypass the PERM process and sidestep the Department of Labor. Not all employees obviously will qualify for those specialized categories, but it's worth looking into.
Yeah, it's true, right? Sometimes, somebody has these qualifications that aren't listed on their resume, and it's a nice surprise when we can find that a person can potentially bypass the PERM process. So appreciate your insight, Miki, and we're excited to continue our PERM conversation with part 2 next week, where we're going to talk about recruitment methods, specifically Department of Labor versus the recent Department of Justice settlements regarding Facebook and Apple. And then part 3, which will be the beginning of June, where we'll talk about reductions in force and job changes. So until then, if you don't already, please follow us on our LinkedIn page for WR Immigration, as well as our individual profiles. If you have any questions, feel free to DM us. And we also transcribe the live stream of this to a weekly newsletter that you can subscribe to, and the link to subscribe will be in the comments. So looking forward to part 2 and see you again, Miki. Have a great day.
Thanks, Kimberly.